Are you going to make a motion?
I am, ma'am. Are we on?
We're on the books.
Okay.
I think he has a motion to make, and then I have a response, and then it'll be up to you.
I am requesting that the board postpone this hearing, adjourn this hearing, which is provided for under the rules governing this board, to give me the opportunity to research what belief Mr. Dean might have in regards to the composition of the board and in regards to my belief that the board may be so poisoned by some of the statements that have been made and may lack impartiality. And impartiality is a key principle, a bedrock principle of this board. In fact, the board's own rules state very clearly, not only must the board be absolutely impartial, it must always appear to be so. From where I stand, and I'm not questioning your integrity or your motives, I just feel like there may be some evidence of lack of partiality and some evidence that suggests that Mr. Dean may not be able to get a fair shake, especially after some of the comments made by Mr. Winters. I'm not sure what led him to suggest that I may want him dead, but is that type of remark that I believe has infected this body and may have rendered it unable to make a fair and impartial decision with respect to Mr. Dean. During whatever adjournment, if you grant it, I will research the issues to see if I need to take any additional steps on behalf of my client. I think this step is necessary now before this board renders any finding and forwards it on to the county manager for absence. Your own rules state that there is no other level of review beyond you. Your own rules do not state that I may go to the county manager and address this matter with him. Since you're my final step of administrative review, according to your own rules, you're my last best hope. And for Mr. Dean's last best hope. And if we feel that, given the comments that have been made, that this board may lack partiality, may not be able to render fair and impartial judgment in this case, we need a postponement so I can review the issues, review it with my client, and see what our options are, in essence. I regret that it's come to this. I certainly didn't mean to cause any rancor here today. The only thing I'm trying to do is get to the truth. That's all. And my client's job is on the line. He lost his job as a deputy. I think he lost it wrongly. Not that he didn't engage in some offenses that he should not have, but I don't think the punishment fit the crime. And I'm here as best I can to try to address that situation and convince you good people to potentially reinstate him. Certainly he deserves some punishment, but I feel like the board is not really able at this point to listen to me thoughtfully and render a fair and impartial verdict. And I need time to review what steps I can undertake, if any, to right that situation.
The question I assume you have, first of all, is whether or not you have the ability to grant a continuance. Your rules under section, Roman numeral 4, B, in the middle of there, it doesn't have a separate number, says, the board may grant continuances or adjourn the hearing from time to time upon its own motion, upon joint request of the parties, or for good cause shown upon the request of only one party. Failure to grant a continuance for good cause may make the proceedings vulnerable. It's the county's position that, and I've told this to Mr. Blitch, that you are an advisory board only. You do not make any decision, any final decision, that is the county manager's role in this pursuant to the merit rules. I've suggested to him that he allow you to do your jobs today and I think we're closer to done than we are to the beginning. I know the sheriff's my final witness. I also feel from the perspective of a continuance that I think there's some unfairness to the county at this point because we've laid out our entire case so far, and we haven't seen anything of his case. But that's beside the point. My opinion at this point is that, and my suggestion to him was that he allow you all to do your jobs, make your recommendation to the county manager, and prior to the county manager making a decision, that he has the ability to make his concerns known to the county manager. The county manager can listen to the entire hearing if he feels he needs to make sure the due process has been done. And so for that reason, we are opposing any continuance.
May I respond to that?
Yes.
There's no procedure in here for me to discuss this matter with the county manager. And unfortunately, once the horse is out of
But
the
we're
barn,
not, nobody's gonna stop you.
The
Ma'am.
merit
All
rules
you have to do
say
is make an appointment with him.
ma'am,
he is allowed to consider things that are not part of the record in making his decision under the merit rules.
ma'am,
Yes.
if I may.
Mm-hmm.
Due process of law requires that this man be afforded an impartial tribunal. And somebody to hear his case without any preconceived notions or any ill will or any other thing other than objectivity. If this board fails to grant this motion and proceeds to this hearing and makes its recommendation to the county manager, I don't feel that due process will, the requirements of due process will be served. These are constitutional issues. They're not just, niceties. They're not just, airy statements. They're bedrock constitutional law. If a board does not have impartiality, I've raised the objection. I'm asking for time to study the matter, see what options might be available to my client. Not only that indicate additional bias, because my request is reasonable, but it would also potentially be a constitutional violation. So I respectfully request that an adjournment be granted. I don't know that we, I'm sure that given the fact that we've already been through this once, we could probably do it once again much more efficiently. Perhaps opposing counsel might get into some stipulations about facts and evidence to help streamline the process. You're shaking your head no.
I'm opposed to a continuance. That's what I'm shaking my head on.
Okay,
I'm
well,
opposed to a continuance.
you made your position, I made mine. But if this board denies this request, which I think is a reasonable one, I think would only lend itself to even more of an assertion that bias doesn't exist.
Do you have a comment?
I have a question.
Okay.
Since we're the board, everybody here, excuse me. For the continuance, what's going to change? You're still going to come back to the same board.
Sir, that's what I'm going to research in the interim between the two hearings. Ms. Jones has made an assertion that you're unremovable.
It's not an assertion, it's what the charter says.
I haven't had time to read it. And I would like to study, that's my problem.
I said, that's not my problem.
Well,
That's what I said. I didn't say
unfortunately,
was
it
your
is
problem.
my problem for purposes of properly advising my client. I would like to test her assertions. I find it unfathomable that this board can't be removed.
That's not a valid reason for continuance of the hearing.
Excuse me, may I?
You have
I
to.
find it unfathomable that this board simply can't be removed for any reason at all. Now, am I suggesting there is enough evidence to warrant that? I don't know. That's why I need to look at it. I'm not making these statements because I question anyone's integrity. I just feel that the comments that have been made and some of the rulings that have been made may indicate some level of bias that will prevent my client from receiving a fair hearing. I'm not questioning your honesty, your integrity, your intelligence, or your good nature. This is purely about my client's ability to get a fair shake.
I need to add one more thing on your
Please.
Due process is something that's considered in the circuit court level once the decision is made by the county manager. I believe they're actually seeking certiorari in the last case that Mr. Blitch handled in the circuit court. So there is an appeal process of the county manager's decision which would take into account what you all have done and whether or not he was given a due process. So it's not the end of the road here if he loses or if the county manager upholds the termination or whatever that decision may be. The next step through our legal system is a petition for certiorari through the circuit court and then to the 5th District Court of Appeal and to the Supreme Court if he needs to. And due process is one of the issues that's considered at that level.
With all due respect, ma'am, and I don't have the exact figures in front of me, but the flush petition cost my organization more than $10,000, and the costs are ongoing. I'm seeking to avoid those costs. I'm also seeking the necessity of dragging the county into litigation if that becomes necessary. I don't want to do that. I'd like to get this matter resolved. But to say that I've got remedies in the 5th DCA and the Florida Supreme Court and whatever appellate court might be available is really kind of silly. I'm asking for time to study the issue. If I can put the matter to bed, I will, and there won't be any further concern or argument about due process, Expenditure of attorney's fees can be avoided. Additional rancor between the Teamsters and the county can be avoided. And the county won't have to spend money on defending my petition for certiorari. So a little patience here will go a long way to saving everybody a lot of time and money.
I have one final word on the due process issue, because I think the law allows for a procedure to allow him to determine whether due process was given by you and by the county manager. Your burden today to decide on a continuance is whether or not he has shown good cause for a continuance. The argument that he has no other way to make sure his client gets due process is not a valid argument. And I have 3 cases from Volusia County employees that were appealed that talk about the due process of the hearing, and that's the provision, if he thinks he's not getting due process today, that allows him to do that, not to get a continuance of the hearing.
Well, I'll try to make this my final word. Those procedures are in that packet for a reason. They're built and were conveyed for a purpose. And that purpose is, I believe, to give me the opportunity to adjourn this meeting, research the law, research the county's rules and regulations, research the county's charter, to see if my client has a leg to stand on, and also research due process issues relevant to what we're arguing about today. Doesn't it make sense for the taxpayers of Volusia County, Florida, that we resolve this issue now rather than spend tens of thousands of dollars on attorney's fees later? I would think, as stewards of public money, not you particularly, but Volusia County would be interested in avoiding the unnecessary expenditure of attorney's fees.
Yes.
I for one, am not supportive of a continuation. I do not believe what Joe said has biased my opinions whatsoever, and you'll have to answer that one for yourself, but it hasn't affected mine at all. And I think that since he has recused himself and left, that we can continue this hearing, and then if he's got some questions and wants to appeal it, he has the ability to do that. And I believe that the county manager will listen to these hearings, and I think he's got other ways to handle this. But it hasn't biased my opinion. I want to know the facts on your side and on your side, and then we're an advisory board, and we will advise what I think is what we feel is correct. I'm not supportive of continuation.
DC, you got anything else to say?
Yeah, no need on the bank account. We are advisory. So to me, there's recourse, even if we were dead wrong.
Yeah.
There's recourse after this, so I'm not concerned about it. So I think we should proceed.
Yeah. I agree, we're a voluntary board that just advises what we think to the county manager. Your recourse is to the county manager, I feel. So I'm not going to grant a continuance.
I'll reserve my objection for appeal. Thank you.
Okay.